Hello, everyone. Welcome to the first part of our three-part series online seminar on women's land rights and development in Africa. Just to give you some brief background information, my name is Peter Wendo. I'm the project advisor of the Rule of Law Program for Sub-Saharan Africa of the Konrad Adenauer Foundation. And our foundation has been on the forefront of promoting and protecting human rights, as it forms one of the main pillars of our work. Towards this end, the Rule of Law Program for Sub-Saharan Africa in particular has been contributing to the realization and enjoyment of human rights for all. And since 2006, this is what we've been doing on the continent in 49 African countries. And in the last 4 years in particular, the program has endeavored to advance women's rights out of the realization that sustainable development on the continent can only be attained when the process, the challenges, the opportunities, and the benefits of such a venture involve everyone in society. As you well know, human rights, economic and social development are symbiotic in nature. It is impossible for human beings to enjoy unfettered human rights compliant environment and attain sustainable development when such an environment is sagging under the weight of food insecurity, for instance, malnourished and unhealthy population, and other poverty-related struggles. Land rights in particular are critical components for livelihoods, dignity, and survival. Yet it is an open secret that it is one of the areas that women in Africa face brutal discrimination. Many African countries have entrenched patriarchal legal systems and cultural practices in regard to land ownership, land usage, and access to land. Paradoxically, many of these countries have also ratified international treaties such as the Convention on the Elimination of Discrimination Against Women, and some of them have even gone further and have enacted national laws whose supreme objective, at least on paper, is to curb against gender inequalities. These obstacles inevitably hinder women from enjoying their basic human rights. With agriculture forming the backbone of many African economies, limiting women's access to land and denying them secure land tenure effectively prevents more than half of the population on the continent, especially those who are in the rural areas, from secure access to their primary production assets, which the net effect of this is perpetual poverty, and it undermines women's full potential to contribute meaningfully to their personal and community development. This series seeks to offer a platform to all of us, and this includes men and women, to interrogate some of the legal framework and cultural practices that are in place with a view to remedying the situation as we pursue an all-inclusive growth. The emphasis of an all-inclusive discourse is informed by our strong conviction that strengthening women's rights, which includes land rights, and ensuring gender parity is a shared responsibility, and it is not a men versus women tussle. We hope that you will find that you will all participate actively in this discussion. You will also offer viable options for considerations towards achieving women's land rights in Africa for sustainable development, and with women on the continent forming the largest portion of our population. That number alone is ground enough for every effort to be made at all levels to ensure that their participation is secured and their voices are heard on matters development. With these few remarks, I now hand over the session to our two moderators, Dr. Olivia Luabukuna and Dr. Makanatsa Makonese, to guide us through the remaining, through the discussions. Over to you, Olivia and Makanatsa.
All right, thank you so much, Peter, for that very interesting discussion. I would like to coach this seminar or webinar within the context of the series that started back in 2017, which essentially was setting up a platform for deconstructing concepts that remain important to the discussion on exclusion, inequality, and dispossession for Africa's larger half. And essentially that's what we are here to talk about. And this particular one essentially is meant to delve deeper into the realization that the dichotomous lenses with which we use to reflect, on one hand, the progressive legal provisions that are set up to provide for women, even though these legal provisions are neither uniform nor at the same level throughout every African country, and compare those to the reality, essentially, of exclusion and discrimination that women in Africa find themselves facing within different spheres, but especially the economic ones. And for Africa, whose larger communities live in rural areas, that happens to be mostly couched in land dispossession. And so this particular session is about going deeper into that discussion. I want to allow Makanatsa to introduce our panelists that we are going to be having today before she essentially allows them to take on the discussion. Makanatsa?
Thank you, Olivia. Thank you, Peter. And I think what I'm picking from both your brief presentations is the fact that access to land, particularly for women, is important for the enjoyment of other rights, many other rights that people should enjoy. And these include rights like right to food, right to water, right to livelihoods, and even rights like health and education. And therefore, I think as we proceed with our webinar, we'll be able to get much more from the very distinguished presenters or panelists that we have with us today in this webinar. The first panelist that we have is Rutendo Magadzire. She's a legal and program officer with the Zimbabwe Women Lawyers Association. She will present on uncovering Zimbabwean laws regulating land, property, inheritance, ownership, and control, and will be speaking specifically from their experiences as the Zimbabwe Women Lawyers Association. Our second panelist will speak about legal recognition of customary land tenure and women's rights, and will be speaking from the Kenyan perspective. And this panelist is Honorable Justice Mr. Oscar Amugo Angote, who is a judge of the Environment and Land Court in Kenya. And the third panelist will speak on displacement of women under large-scale land-based investments, and speaking specifically from the experiences of Zambia. And this is Dr. Fatima Mandu, who is a law lecturer from the University of Zambia. We'll give the panelists 15 minutes each, and after the 15-minute presentations by all the three panelists, we'll then go into a question and answer session, as well as a discussion session. So without further ado, I'll ask Rutendo to give us the first presentation. Rutendo.
Thank you, Makanaka. Good afternoon, everyone. My name is Rutendo Magadzire from Zimbabwe Women Lawyers Association, and I will be doing a brief presentation on land co-ownership, joint registration, and the law from a woman's perspective, bearing in mind the laws that we have in Zimbabwe and the practical experiences, and also looking at how cultural practices has actually deprived women of owning or jointly registering properties in their names with either their spouses or their relatives, or in their own capacities. So we have noticed that there are a lot of studies that have been presented so far which have shown that women are have a crucial contribution towards the acquisition of property by men, and also they have a crucial contribution towards the global economic growth. But the percentages of women that own land, be it agricultural land or mining land, or land which is recognized in Zimbabwe as the A1 land, which is land from the communal areas or the rural areas, which is used by women for farms, they are still disproportionately a very small number as that which is owned by men. And these studies jointly supported by the UN Women Watch of 2011. There was a WUSA research in 2019. There was a HIVOS Women in Land and Women at Work study in 2017. And also there was the African Institute for Agrarian Study, and they've combined together. There is a consensus that less than 24% of women have title over land in Zimbabwe. So in Zimbabwe, women constitute, just to give you a demographic view of the percentages of women in Zimbabwe. In Zimbabwe, women constitute 53% of the population, of which 86% of these are residing in the countryside, which is the communal lands, and depend on land for their livelihoods, and they provide about 70% of all agricultural labor, which data was shown by a research from Women in Land, which was in 2008, and has since been consistent with it just changing with a percentage or two, depending on the area that has been focused on. So Zimbabwe, like any other sub-Saharan countries, we have noted that women in general have been providing for the backbone of the economy and have been providing for their families, but basically they are seen as mere household producers and more likely customarily given indirect access to land, which is acquired through their kinship relationships as mothers, wives, sisters, daughters, but do not specifically own land. So in terms of our legislative frameworks, we have our constitution, which in general, it is a true reflection of being gender sensitive, because in terms of our constitution, Zimbabwean Constitution Amendment number 20 of 2013, we have firstly section 17, which states that the state and all its institutions and agencies of government at every level must take practical measures to ensure that women have access to resources, including land, on the basis of equality with men, meaning that there is a progressive realization of the right of equality, because prior to this, before women, there was no equality clause with regards to giving an obligation to the state to observe equality of rights during access to land. And then we have our section 56, subsection 2, which is also progressive as compared to other African states, as it states that women and men have the right to equal treatment, including the right to equal opportunities in the political, economic, cultural, and social spheres. So these equal opportunities will also speak to the acquisition of land. I would want to make a comment there that we cannot separate the issue of land, particularly in Zimbabwe, to the issues to do with politics, and our economy, because Zimbabwe, the backbone of our economy is greatly supported by agriculture. And as such, on the aspect of politics, I think you will see when I give examples of our lived experiences, to see that land also is supported or is works hand in hand with politics. So section 72 as well of the Constitution, it then attests to the right of agricultural land, which right is given to everyone, but it does not include communal land or land which is within the boundaries of urban and local authorities. The communal land in terms of the Constitution is land which ownership is reserved for the Zimbabwean government or the state itself. Then urban and local authorities also have, we also have our specific acts that then speak to that kind of land, which would then also be regulated by our Deeds Registries Act and so forth. But to comment on that, the reservation of land in communal areas is belonging to the state. It reverts women back to the position that we were in colonial times, in which access to these opportunities are greatly reserved to men. I think as I explain, you understand why I am giving this comment, because basically communal lands, in terms of a statutory instrument, which is referred to statutory instrument 53 of 14, it regulates that women can apply for land and apply permits in their own rights. But however, in this same statutory instrument, it is realized that apportionment of these, what they are referred to as A1 farms, are guided by customary systems and local systems, as they indicate how this land shall be shared, and in terms of conflict, how they should be adjudicated. So by virtue of including the issues to do with custom and customary systems, it then puts women on a disadvantage, because most of these times we are then looking and giving precedent or power to traditional leaders to continuously assess and determine how land would then be shared. I will give a lived experience in terms of this communal land. We have had women that come to us as Zwala for assistance, noting that they have settled on land based on a man that has married them, and then by virtue of them having to separate with this man, they are told that they cannot be apportioned a portion of land, because this land will be given title, or will be there will be a holder title in the name of a husband in communal lands. So as such, our traditional leaders are then failing to share that land. I'll give an example of another case that we were faced with. This was a case of a woman who had been married for over 40 years. And then when she was married over 40 years, and then she was about to separate with her husband, she could not share this land because the title holding was with her husband, and the communal traditional leaders were noting that this area, which is regarded as a traditional home for this husband, could not be repossessed by another person. So as such, women have been dispossessed or have been taken, have not been given the right, the equal treatment to own property and land, especially when it is under these farm permits or under communal land, which is headed by traditional leaders. Then we have the National Gender Policy. It still fosters gender equality and opportunity, even in acquisition of property. But our African customs will still remain as hindrances, as most of the traditional leaders that are implementing this, in our experiences, they fail to then implement gender policies that will be looking at the equal realization of rights and capacities of women. In fact, women are still being treated as perpetual minors in certain areas. In certain areas, we have been experiencing a fair share of realization of equality or rights of women, but there are certain areas where the traditional leaders, I can say older traditional leaders, who do not then adhere to international treaties and policies and the constitution itself, they remain to treat women as perpetual minors and do not concede to the fact that women have the capacity to own land in their own right, and continue to even apportion them land. If, for example, in the instance that in their family, if her husband dies, they will allow use and possession of land. If they have a son within that family. So we also have the Married Persons Act in Zimbabwe, which in its right, I have included this because it tallies with the Deeds Registers Act. In terms of the marriage laws in Zimbabwe, we have all marriages in terms of the Marriage Persons Act are out of community of property. So as such, it then includes that the registration of properties during the subsistence of a marriage will not have or require the consent of another party. As such, women, because of the patriarchal nature of our society, have been losing out on registration of properties. And we have realized this, especially when women come to us for assistance at the dissolution of their marriages, when they then need to share property. We have realized, in statistically speaking, that most of these properties will be registered in the husband's name. At the dissolution of the marriage, there is then a recourse that women can also then register properties in their names when this property or this land is shared equally amongst them, especially land which is private and which holds title deeds with the Deeds Registries Act. But however, the problem then comes in that during the subsistence of a marriage, our constitution guarantees equality of rights during marriage, but at the dissolution of the marriage, this is when people are getting the recourse to be able to share this land that they have jointly acquired but not jointly registered. Jointly acquired, I mean they have joint resources for the registration of the property. So this has been a very great challenge in Zimbabwe because of the nature of our marriage regime. As such, women have been losing out on ownership of land, which then justifies the less than 23% in which survey and study has shown that women are still lagging behind in the registration of property. We have, however, ratified certain international treaties, the Universal Declaration of Human Rights, which guarantees equality of rights, African Charter on the Human and People's Rights, the Convention on the Elimination of Discrimination Against Women, which CEDAW Shadow report, we have also reported on it earlier this year, the Southern African Development Community Protocol on Gender and Development, but all these ratified international statutes can be considered as progressive step towards upholding and promotion of registration of properties in women's rights and their ownership. However, the challenge still comes when we look at the issue of our custom. Our custom still looks at women as perpetual minors, and most of our women, most of Zimbabwean women reside in these communal lands where they are still under the law or the rule of traditional leaders who still insist on women being perpetual minors and women not having the capacity to own land. Women who are now registered as owning land are educated women, women who are in towns, but also survey has proven that even those who are educated are still being, I can say, manhandled by patriarchy and the power that comes with men when they are included, when they ratify or when they solemnize their marriages. So we have noted that women currently are assertive of the securing of grower products and continue to tilt, plant, and harvest land owned by their husband and brothers. It is also a challenge in terms of our customary practices for women to own land, because from our engagement with the community, especially those in communal areas, they are now quite very assertive of the governmental schemes that allows them to assess produce for production. For example, they are given seeds, they're given fertilizers and so forth. But when they tilt and then have an end product, they are failing to realize money for them to be able to purchase land based on the issue that after they harvest whatever plant or crop that they have, men are tending to take money. This is mostly on land that is mostly on farm produce, for example, tobacco. Men are then coming to the towns and selling their tobacco when the floors are open. So, and then they go back home after 2 weeks and that money will be finished. So women are failing to then realize or to even secure funds to then register properties in their own right, or to even register to be part of to be part of the schemes for land distribution. But however, we have noted that our Ministry of Lands, Agriculture and Rural Settlement has adopted certain practices, which includes the registration of tenure documents, because we also have 99 leases on agricultural lands, which is controlled by the government. On securing of these tenure documents, they are only approving it after the satisfaction of the registration of both names of spouses in the event that the people are married. And also this has been adopted by our local council regulations, in which registration of properties, they are jointly registering it, therefore rendering spouses as joint owners of properties. The local government has also done the same, but the challenge with this is it is being practiced at council level, and it differs from town to town. Some councils are assertive, some councils are upholding these gender policies that we have, that speak to equality of rights in agriculture.
It might seem that we are losing Rutendo.
Let's proceed. If she has got any concluding remarks to make, we might give her that opportunity at the end.
Yes.
Yes, so I think we can go to the next presenter, but I think what I can pick from Rutendo's presentation is the fact that despite the many good laws, including a very progressive constitution that Zimbabwe has, this has not quite assisted in terms of ensuring that women are able to access land on the basis of equality with men. And in the case of Zimbabwe, I think what is more disconcerting is the fact that the country embarked on a land reform program about 20 years ago, which was supposed to address historical imbalances in relation to land ownership, access, and control. But what we have seen is that the focus in terms of addressing those historical imbalances has been mainly on addressing racial imbalances, and not much effort has been put in place in terms of making sure that that process of reform also addresses the issues of inequity when it comes to access to land by women in the country. So probably the processes that are being implemented at the moment by governments at ministry level and the local authorities at local authority level would be useful if they actually, put into legislative frameworks so that they become more binding and are used more often and in a more regular way in ensuring that women are able to access land on the basis of equality. On that note, I'll ask Honorable Judge to come in and make his presentation for 15 minutes, and then we take it up from there. Thank you, Judge.
Yeah, thank you very much, Dr. Makanatsa. I want to start by echoing the sentiments by my co-panelist, Ms. Rutendo, and everything that she has said about Zimbabwe replicates in Kenya, and therefore I will not actually repeat what she has said in terms of how women have been disempowered when it comes to ownership of land, despite the fact that they contribute immensely in terms of the economic production of the country. Now, my brief paper will simply analyze the interface of the legal recognition of customary land tenure and the women land rights in Kenya, and more so how we have moved from one region legally to the other part. Now, when we talk about customary law, we all know that customary law actually plays a significant role when it comes to disenfranchising women in terms of land ownership. And this customary law in Kenya is actually part and parcel of our laws. So we have to live with customary law, but in such a way that we implement what our constitutional provisions provide for. Now, customary law in Kenya is recognized under Article 2, Sub-Article 4 of the Constitution as a law which governs this particular country. Now, that particular article, that's Article 2, Sub-Article 4 of the Constitution, actually provides that as much as customary law is applicable in the country, it should be inconsistent. It should be consistent with the Constitution. And other than that, the same customary law should not be repugnant to justice and morality. And of course, the issue of what is justice and what is morality has played out in our courts for many years. Now, the Land Act, which was actually passed in 2012 after the 2010 Constitution, also recognizes the customary land rights. And it defines customary land rights as rights which are derived from the Kenyan customary law. Now, the Land Act also clarifies that definition by stating that the Kenyan customary law is supposed to be in tandem with the written laws, so that, as I will show later, the customary land tenure in Kenya is part and parcel of the land tenure, but it has got its own limitation on its application. Now, as my sister Rutenda has just said, customs generally are derived from the practices of communities, and where we all know the history of land ownership in this particular country and continent as a whole, whereby women only had what we can call user rights over community land, meaning that women were only allowed to own land in terms of user rights and not in terms of ownership. So that the user rights of women were tied to their relationship. So that women were supposed only to use land either as sisters or as wives, and not as owners of the land in that particular, in most of the communities. And the Kenyan customary law has for a very long time been patrilineal in terms of inheritance of land, which is more or less the same thing as what my sister Rutenda has told us about Zimbabwe. That has been at play for so many years, I think since time immemorial. And this patrilineal kind of ownership of land, where land passes from one man to the next one, is definitely discriminatory in favor of men. And that has been practiced for a very, very long time. I would just like to give us a brief historical background of how customary land tenure in Kenya has evolved over time. Kenya was a colony of British between 1895 to 1963. And during the colonial period, we had two sets of laws, the laws governing the non-Africans and the laws governing Africans. And if you read the history, you will see that the law governing the Africans was mostly customary laws. And all the disputes revolved around the personal relations, family law, and land tenure and succession generally was actually practiced in the native tribunals, and the laws which are applicable are the customary laws. And that explains why the customary laws actually took root in country during the colonial period. And when Kenya attained independence in 1963, you'll find that under the 1963 Constitution, which was repealed by the 1969 Constitution, the rights of women to own land were not recognized. Indeed, that's where the rain really started beating us as Kenyans, because when you look at Section 82 of the 1969 Constitution, which we repealed in the year 2010, though Section 82(1) actually disallowed the enactment of discriminatory laws, you find that under Section 82, subsection 4 of that repealed Constitution, it allowed the adoption, or rather the enactment of laws which were discriminatory in respect to adoption, marriage, divorce, burials, and devolution of property on death. So the law actually allowed or constitutionalized discrimination when we look at the 1969 Constitution and also the Independence Constitution of 1963. It is very strange that indeed we had that piece of legislation in our Constitution for quite a while until the year 2010. And that particular provision is what was used by courts just after independence for very many years to entrench customary laws, which actually had the effect of disenfranchising women. One of the notable cases which played out in our courts up to the Court of Appeal and which dealt with the issue of customary law was the SM Otieno case. And I think most of us know about that case, whereby the Court of Appeal upheld the application of customary law and made a decision that the widow of the prominent lawyer SM Otieno cannot be able to bury SM Otieno because the personal law that actually was at play was the customary law of my brothers from Luo Nyanza. So the issue of discrimination against women was entrenched by the Independence Constitution of Kenya in terms of Section 82, subsection 4, which actually allowed the passing of laws which are discriminatory when it comes to matters of inheritance. And that's what was used actually to entrench the issue of disenfranchising women when it comes to owning land. So let's come to the year 2010. This is when we really had we revamped our constitution in terms of recognizing the rights of women and also disallowing discrimination of any nature in terms of ownership of land. And when you look at Article 27, sub-Article 3 of the Kenyan Constitution, it clearly provides that women and men have the right to equal treatment and equal opportunities. And the catchword that I want to use for this particular presentation is cultural and social spheres. The Constitution disallows any kind of discrimination when you're discussing issues to do with culture or social spheres. So culture, when you talk about customary laws and rights, you are talking about the culture of the people. And the Constitution recognizes that we have some cultures which are discriminatory in nature. And that includes the fact that most of the customs or most of the customary laws did not allow women to own land, either through inheritance or otherwise. So Article 27, sub-Article 3 is very clear on that issue, that you cannot discriminate women on the basis of culture or any other social spheres. Now, after 2010, of course, there have been so many reforms in terms of the rights of women to own land, as much as our customary laws are still subsisting in our statutes. I'll just pick out two land statutes which are now in use. The first one is the Land Act of 2012, which provides for the forms of land tenure in Kenya. And of course, we know of so many other land tenures, including freeholds and leaseholds. And Section 5 of the Land Act also recognizes that we have another land tenure system called customary land rights. It is specifically stated in Section 5 of that particular act. So actually, somebody or people can own land under customary land rights. It's a form of land tenure. However, that Section 5 clearly clarifies that position by stating that there shall be no discrimination in terms of ownership under whatever land tenure that is being practiced. So whether you're talking about leaseholds or freeholds or customary land rights as forms of land tenure, the Act specifically provides that there will be no discrimination when it comes to access and ownership of land under any of those tenures that I've mentioned, including customary land rights. Now, we also have the Community Land Act, which was enacted in 2016. This is the act which actually governs community land, and as you know, most of the discriminatory measures which have been going on in terms of land, they are usually in respect to community land. And the act now clarified how the community land can be owned. One, it recognizes customary land rights, because most of the community land is actually governed by customary laws. And the Act recognizes that indeed we have customary land rights, which are, which as I've said, are defined or are derived from African customary law, customs, and practices. But the Act, of course, clarified that particular kind of ownership. And the Act states at section 30 that every member of the community has the right to equal benefit from community land. So you see, the Act now is very clear that even when you are dealing about community land, which is actually governed by customary law, that does not imply that now the customs that have always been there, the patrilineal nature of ownership of land, cannot come into play, so that everybody, every member of the community, and here we are talking about women and men, are entitled to equal benefit of community land. So you cannot say that because it's community land, it's not registered under any system, we are not going to enforce our customary rights which have always been there to disinherit or to disenfranchise women. So section 30 is very, very clear on how community land can and should be owned by the communities. Now, I will look very briefly at the Law of Succession Act. This is where we've really been having problems, not just in Kenya, but in Africa as a whole, because we know that most of the women have been disinherited of land which they are entitled to as children of deceased parents. The Law of Succession Act in Kenya came into force in 1981. And now, as much as the Law of Succession Act stipulates that every child is entitled to inheritance of their parents' estate, the practice in most communities has been that it's only the male child who is entitled to inherit the estate of his parents. Now, the issue of equality between a girl and a boy, between a woman and a man under the Law of Succession Act is more on paper than in practice, and that has been a problem. But over time, of course, the Kenyan courts have reinstated the law over and over again. But having said that, we still have a challenge when it comes to certain provisions of the Law of Succession Act, which has not been reformed for quite a while. And there are some two provisions of that particular act which have been controversial in certain respects, and which the courts have actually made pronouncement on those particular sections, but are still in our law books. I want to pick out section 35 of the Law of Succession Act, which provides that in case where a woman's husband dies, she is the surviving spouse, in this case the widow, is entitled to a life interest in the residue of the estate. Now the act further provides that if the surviving spouse is a widow, that interest shall determine upon her remarriage to any person. So you can see clearly that this section does not give widows an absolute right to own the estate of their deceased husbands. And the section is only geared towards widows. It does not even talk about widowers. So you can see this is a very discriminatory piece of legislation in terms of confining the right of a widow to own that she's supposed to own to her status in the community, so that if she remarries, then the law disenfranchises her immediately. That is a provision which I will show towards the end of my presentation that the Court of Appeal has had a problem with. But unfortunately, it is still part and parcel of our laws. Now, the other section, which is very controversial and which is still in our law of succession, is Section 32. Section 32 is a very interesting piece of legislation because it provides that there are certain regions of the country where agricultural land and livestock can only be inherited by the customary laws of that particular region. And the regions which are specifically stated in Section 32, which the law says, or which that section says, will not fall in the succession regime of the Law of Succession Act, are we have West Pokot, we have Wajir, we have Samburu, we have Lamu, Turkana, Garissa, Isiolo, Kajiado, Marsabit, Tana River, Mandera, and Narok. These are regions which are actually inhabited by pastoralists. And these are regions, just like the rest of Kenya, where patrilineal kind of ownership of land has been practiced for many years. It's interesting. It's a section of the law that's so interesting to the extent that you wonder why it's still there, because it states that those particular regions that I've mentioned, when it comes to inheritance of agricultural land and livestock, then it's the customs of those regions that should be applied. I've never known up to now why some regions should have a different law applying to them instead of the law which applies to the whole country applying to them. So the Act provides that the law applicable to those excluded areas and those properties is a custom applicable to the deceased community or tribe. So that more often than not, the women who come from those particular counties that I've mentioned and which are specifically stated under Section 32 will be disinherited, because now if you fall back to the customs of those particular regions, you'll find that women are not allowed to inherit land or livestock for that matter. Now, just in conclusion, because I've stated, I don't want to go into the statistics that my sister has gone into because they more or less apply to Kenya. I would like to just state that we've had judicial interventions in terms of empowering women when it comes to inheritance issues, both under the old constitution, despite the fact that the old constitution or the repealed constitution actually allowed discriminatory laws when it comes to inheritance. We've had judicial interventions, especially beginning to around the year 2000, up to the year 2010, before we repeal the old constitution. The interventions that have come about through the judiciary have been pegged, especially before the 2010 constitution, have been pegged on the international conventions, or rather on the conventions that Kenya has ratified as a country. So despite the constitutional provisions which were there, Kenya had already ratified several conventions which actually gave women equal opportunities, and the courts used those particular conventions to stop men in their tracks when it comes to inheritance of land. And one of the notable decisions is by the Court of Appeal in one of the cases which was decided in the year 2004, where the judge, or rather judges of the Court of Appeal, were very clear that Kenya had ratified the Convention on the Elimination of All Forms of Discrimination Against Women. And therefore, having done that and acceded to that convention in 1984, they cannot fall back, or parties cannot fall back to Section 82, Section 4, which was discriminatory in all respects, to deny women of inheritance of land. And in that particular case, the Court of Appeal was very clear that despite that particular provision of the Constitution, women had an equal right to inherit their parents' land. Now, that is pre-2010. We had very few and decisions which actually came to the aid of the women. But after the 2010 Constitution, which now made the rights of women to own property very clear, we've had so many decisions whereby the courts have been very emphatic that women have an equal right, just as men, or boys have an equal right, just as girls, to inherit land that their parents own. And as I've mentioned, the Court of Appeal in one of the decisions, they have also stated that Section 35, which of the Law of Succession Act, which states that once a widow remarries, then she loses whatever interest she had in her husband's property. The Court of Appeal, in a very recent decision in 2014, was very clear and said that indeed Parliament should really look at that particular section because it was discriminatory in all respects. You cannot, one cannot lose, or rather, a woman cannot lose her right to land, which she was entitled to as a widow, just because she has remarried. The Court of Appeal was very clear that that's a law which is discriminatory in nature and which should be looked into. And this particular provision of the law, of course, is being practiced in Kenya more often than not, whereby you are told that if you remarry, then it means you are not going to own the land that you are entitled to as a widow in the first place. And in that particular decision, which looked at Section 35 on the issue of what happens when a widow remarries, the court was very emphatic that under the 2010 Constitution, the yoke and burden of discrimination should not be borne by the female gender anymore. And the court was also emphatic that that is the new dispensation, and that has to be enforced by all and sundry. And that clears the conversation around Section 35 on what happens when a widow actually remarries, even after having inherited what belonged to her deceased husband. Now, I will last look at Section 32, which the courts have also addressed, Section 32 of the Law of Succession Act of Kenya, which, as I've already stated, points out to the fact that there are certain regions of this country where the Law of Succession Act is not applicable when it comes to inheritance of agricultural land.
Apologies for interrupting you. Unfortunately, we are running out of time. If you could kindly wind up so that we have the next speaker.
Yes, thank you very much. This is actually the last statement I was making, that the court has been very emphatic in a very recent decision of April this year, 2010 in Kajiado. The court was very emphatic that the law which actually disinherits ladies in the Maasai, from the Maasai region on the basis of Section 32 is unconstitutional and should not therefore be in our statute books. Thank you very much, and that's my presentation. Thank you.
Thank you very much, Judge. That was a very insightful presentation. I think you touched on quite a number of issues that basically apply in many of the jurisdictions in Africa. And one key issue that I've picked is in relation to the issue of our independent constitutions and the clawback clauses in those constitutions that allowed for discrimination on the basis of customary law and personal law. And I think it's something that almost all of our countries inherited. And the fact that we are now coming up with new constitutions has also meant that such provisions in the constitutions are actually now being taken out. Kenya is an example, Zimbabwe is an example. And the new laws that are coming out of that process as well, as soon as countries have got new constitutions that prohibit discrimination on that basis. So the Land Act in Kenya, I think, is a good example, but still what seems to be coming out, I think, from the presentation is that despite those laws being in place, the actual practice on the ground is quite different and still causes a lot of discrimination, I think, when it comes to actual application, and women continue to lose out, especially if we're looking at the issue of access to land and customary or communal land in particular. Thank you very much for that presentation. I will ask Dr. Fatima Man to step in and give us a presentation. And can you please do it in just 15 minutes so that we have at least a few minutes for discussion at the end. Thank you.
Thank you very much. And I'd like to thank everyone, especially the organizers. I know it's difficult to organize online things, and you've done a great job. My presentation is quite short, so don't worry, I will try and be within the 15 minutes. What the first presenter as well as the second presenter said is equally applicable to Zambia. When it comes to the bigger picture in Zambia, the issue is we have definitely ratified many of the regional as well as the international conventions in terms of trying to protect women's land rights, and especially to prevent discrimination. However, the reality on the ground is very different. Unfortunately, the laws are there, but when it comes to implementation, I don't think even 5% of the laws are really implemented. My paper will look at the displacement of women under large-scale land-based investment in Zambia. Why did I choose large-scale land investment? Currently, the Zambian government is promoting agribusiness through large-scale land investments. And what is happening is that these large-scale land investments require land, of course. So large tracts of land, which are currently held under customary tenure in Zambia, are being given to these investors. And then the rights of the people who are holding customary land is being taken away. So, since we have a dual land tenure system in Zambia, statutory land on one end, which is regulated under a specific legislation, and customary land, which is regulated under customs. Statutory land has evolved with the registration system, whereas customary land is not registered. Matters relating to displacement means that another piece of legislation comes into place, which is the Land Acquisition Act. Under the Land Acquisition Act, the government is allowed to acquire land in order to promote development. And this is supposed to be done in the interest of the public. This public interest clause in the Land Acquisition Act allows the government to do that. However, it goes on further to say that when they acquire land in public interest, the owner must receive adequate compensation. The debate is on what amounts to adequate compensation. And here, the problem is under real property. Because when we talk of real property, we are talking of land. And land, in order to compensate people for land, to put an amount of compensation would never really be adequate. And therefore, the debate continues whether $10, $15, $50, what is actually adequate compensation to the people whose rights are being taken away. The Zambian dual land tenure system has the statutory land and the customary land. But statutory land, which is governed under the Lands Act of 1999, allows for conversion of statutory land into customary land into statutory land, but not the other way around, which means once customary land is converted to statutory land, it falls under the piece of legislation, and therefore all the customary rights are taken away. And when that happens, you cannot reconvert back. So what is happening currently in Zambia, just to give you a background, is that 80% of Zambia's land is held under customary land, and only 20%, and those figures may not be accurate because Zambia has never had a land audit. And up to today, we are still battling with a draft land policy. And the discussions on this draft land policy started in 2006. I've been part of the teams who have looked at all the different drafts. Right now in 2020, that is when we are even thinking of looking at how to go about bringing about this new land policy. So if you talk from 2006 to 2020, you're talking of a wide span of time. And policies and reviews of policies are supposed to take place every 2 years or every 3 years to ensure that the new laws which are being brought into effect are actually in line with what the policy decisions are. So unfortunately for us, this is the background position. And to make matters worse, most of our laws, and here's where the big gap is, are gender neutral or gender blind, completely gender blind. We've always tackled the issue that he includes she, and that's fine for gender, but it does not work. The inequalities are very, very real. It is very difficult to realize when the law simply is supporting patriarchy, and it is definitely stereotyped, and it is made by men to serve men. I'm not trying to be a feminist here, but I think that is the position that is there as far as the laws are concerned. The Constitution, of course, supports non-discrimination, all the other provisions. I think the two speakers adequately covered all the inequalities and the discriminations which are present. The same position is evident even in Zambia. But right now, because of the failed referendum in Zambia, our new Gender Equity and Equality Act cannot be brought into effect. So it was dated 2014. This is 2020. We are still struggling to try and see how we can bring this important piece of legislation into effect. But we cannot. The Act simply says that the minister will bring through statutory instrument this law into effect. Now, until the referendum is cleared and the Bill of Rights is cleared, we are on checkmate as far as the implementation of the Gender Equity and Equality Act is concerned. As a result of all these problems, there is definitely a lot of displacement of women as well as men, as well as children, as well as youth, which is really happening. And it's happening with serious human rights abuses. These commercial farmers have managed to get this piece of land, and they have started their commercial activities, and they have driven the people who are staying there and who have been for generations planting this land as subsistence farmers or utilizing the land, keeping their animals. They have been told to move, and move in most cases without any compensation. most reports say that they are compensated at the most $50. Now, how far would $50 go? Especially when a dollar is 18 kwacha and the rate is 18 kwacha to a dollar. That's very little money in terms of the land that is being lost. What has resulted is on the ground, these residents now do not have a right to their livelihood. What has been taken away from them is the basis of their livelihood. They cannot grow their own food. They don't have the right or access to the water that they need to plant their subsistence farming and carry on their activities, their everyday activities. Women, however, are even more adversely affected by this whole scenario, because the balance is that it's normally the woman's duty to make sure that food is put on the table in most of these rural communities. And therefore, there is a mismatch between the lived realities and what the law is really providing for. Women have got no place under customary law to negotiate with these commercial farms, and they've got nothing to negotiate with in terms of documents, in terms of rights, in terms of the relationship between customary land and statutory land. And in my paper, as I will look at a bit later, there are two important cases called the Pongwe cases, which have really affected more than 60,000 families staying in a particular area in Zambia. These commercial farmers have come in and they have planted wheat at a commercial level, and these families have been displaced, and women, especially women, have been removed or forcefully removed from their land, which they held under customary tenure, and through a court order. And this was the decision of the highest court in Zambia, being the Supreme Court, that these commercial farmers have or are beneficial owners and are protected by the law. And therefore, the people who are occupying the land under customary tenure must be removed. Unfortunately, some of these people do not have anywhere to go. There is no resettlement scheme for them, and they end up staying on the land. In fact, there is records of women who are now serving a criminal sentence for criminal trespass on land which belonged to them for decades. And these women are currently in prison, serving prison sentences. So these commercial farmers, supported by, of course, the government, end up disrespecting the human rights of these people who have been there. And in the end, what happens is that all that these women are left with is maybe given a tent and a shelter to work from. But how are they going to then live? What are they going to eat? Where will be their access to water? And all this is left out completely from the equation. So the interaction between statutory land and customary land in Zambia is a basis of all these problems. The problem is where one system is compared as being superior to the other. Statutory land is considered to be superior because customary land, according to most of the arguments, is that it is held under customs which differ from one tribe to the other, and there is no systematic protection of women's rights under all these customs. I will give you an example of the Lozi customary land. Writers like Professor Munalula have written a lot on the Lozi customary law. And under the Lozi customary law, according to the research that she conducted, married couples did not own property jointly, nor did they inherit property from each other. Where a man settles in his wife's village, and this occasionally happens, she's cultivating her own land. The only right that she gets is a user right to cultivate that piece of land. And he has got no claim to any of the crops that she has grown. Traditionally, every male head of a household is entitled to land for his home and cultivation, and his male children inherit this land upon his death. Women can never acquire land or have property of their own. They have to reside with their parents, husbands, sons, and all this happens. Women are not involved in any land transactions that take place. As a result, problems occur when either a lady loses her husband, or when she gets married, or when she moves from one place to the other. Even acceptance in a different community is a real big challenge. So these displaced women are now faced with a bigger problem of having to deal with customary or customs at one end, and the fact that their human or their basic rights have been taken away because of the commercial large-scale land investment which is taking place. In terms of, not everything is lost, in terms of not a solution, but something.
Dr. Mandu.
Yes.
Yeah, sorry to interrupt you as well. We have gone 20 minutes into your presentation. If you can please wind up.
Okay, the last statement, that what we are trying to do is to introduce the social tenure domain model to provide some form of protection for these ladies who hold rights under customary tenure. Thank you very much.
Thank you very much, Dr. Mandu. It's unfortunate that we are constrained for time. I can see that you still had a lot to say, and hopefully we'll be able to share the rest of the presentation so that we can share with the participants, those that we can reach, and make sure that it's available to them. But I think one important issue that I've picked from your presentation is the issue of the insecurity of customary land, and the fact that when large-scale land investments are taking place, government has got so much leeway to evict the occupants of such land, the majority of whom are women actually, who stay on such customary land, and at the end of the day, they get evicted with little or no compensation. So I guess, again, just like with regards to the other issues that have been raised in relation to Zimbabwe and Kenya, the issue of large-scale land investments is also not peculiar to Zambia, but it's also a challenge that is being faced by many other communities who are on customary land in Africa. Thank you very much for that presentation. And with that, I'll hand over to my colleague, Olivia, to moderate the next session on the question and answer segment. Olivia, over to you.
Thank you. Thank you very much for that very interesting and amazing session. It surely ties up the issues that this workshop has been engaging with since 2017 when we started this particular workshop series. And I think, as we noted, and that is linked to the three presentations, then we started from a wider perspective of looking at economic rights and exclusion for women as a way of ensuring that promotion of these women's development could essentially take place. And somebody had asked a question earlier in the panel, what is women's rights to land got to do with development? And well, from the presentation, everything. It has everything to do with development, because access to land, which is an economic resource, allows these women to do a lot of things that could essentially contribute to their progress, including the ability, the basic ability to tend the land and sell your own produce and receive payment from that produce and do whatever it is you want to do with that payment, whether it's building a house or buying another piece of land, as Rutendo pointed out, or educating your kids, or using that particular piece of land as the basis for acquiring more financial support from financial institutions. So it has everything to do with land. So most of the poverty cycles that African women find themselves in, especially in rural areas, in relation to land, come from the fact that they do not have access to this resource, and their access is limited, so they can't essentially use it for purposes of essentially having a financial base and a financial autonomy. So that's where this all workshops started from. And we went on narrowing it to this particular discussion where we come into land, because when you talk about economic rights, it can be wider. And so for today, I want to bring in our participants who have had very interesting discussions among themselves, but also they've had in very interesting questions. I think I'm going to start with the one that came in right here at the end, and then we'll work my way up. And this is to all our panelists. So one of you can take it, or you can all essentially engage with it. From Miriam Maina, and our question is this: how do we end cases of stigmatization where courts have ruled in favor of women to inherit land, particularly in traditional areas where patriarchy and customary rules are essentially in control? So on one hand, you have women who have a right to land and are legally registered when it comes to this particular land. But because of heavy traditions and this particular right is essentially not recognized in those areas where customary laws and rules are essentially strong. How do we approach that? I'm going to let somebody else pick up the question, perhaps Rutendo, and then we can go back to Justice Angote when he sorts himself out.
Okay, on the aspect of having to instances where women are awarded the right to property by the courts and by the law, go back to the community, and they are not awarded the same. I think there is need for us as communities to set penalties for such religious leaders that then do not adhere to it, because they tend to hinder the progressive realization of equality of rights and women's rights, women being the most marginalized group. So the tolerance of these people, it keeps us, it kind of then assumes as if it's a clawback action, where on the other hand, the government is giving us this, and then in terms of the practices, women fail to assert those rights. So I think there is need for criminalization of such acts, because as much as they may go against the African customs, if I heard correctly, even in Kenya, our constitutions are saying any custom that goes against equality of rights or the rights of an individual then becomes void as such. So if there is someone who wants to uphold such a custom, especially in terms of our traditional leaders and our community leaders, if they want to uphold such customs that then infringe on my rights, there is need for our governments to have a penalty and criminalize it. That way, realization of women's rights, the progressive realization of women's rights and acquisition of property by women will be assessed fairly. And just to speak on before my network also acts up on me like it did on my presentation, just a comment on the question that you last answered, which was speaking on how do women influence development. There are a lot of research cases, baseline studies that have been made that show that women are the backbone, for example, of agriculture, with having over 80% of women working in agricultural lands and therefore contributing to the production and subsequently the economy of many countries. So as such, I'll give an example of a Zimbabwean case that we are facing. It's called the Schengen family in Chiredzi case, where the state is effecting Section 72 of our Zimbabwean constitution, which allows it to take certain land if it is to be used for public interest, because they want to be planting lúcan grass, which is used to feed livestock, but they are taking the land from people, women specifically, who have been living in that area for a long time and who have been farming cotton, including sorghum, which sorghum they have been selling to one of the biggest Zimbabwean companies called Delta, and in realizing the continuous production of African beer, the Zimbabwean African beer, and also moving themselves away from poverty. So by them taking this, it means many families, there are hundreds of families, are going to break into poverty, and after breaking into poverty they will not be able to sustain them. So as such, women are still the backbone of development when we speak to issues of owning land. And from our study as well, we have noted that most women work in communal lands, rural lands, and then there are issues of their husbands or relatives then having to take that produce and remitting it for their own benefit. But still it translates to women having put so much effort and physical input into the development of the economy.
Okay. Thank you very much, Rutendo. Before I put the same question that was asked to Judge Angote to finish, there's a comment here from Moza Jadid, who in a way responds to the same question I asked. And it says that engaging with the community in its different membership at its own language or through its own language becomes important. That includes understanding where these norms and practices, the cultural norms, come from, and why they discriminate women. Then we can share with the community equality from provisions, and that's essentially legal education from a perspective that is informed by the community's beliefs. So I think Moza's comment responds to this by saying that criminalizing maybe could be one way, but also engaging with the community from the bottom up as opposed to the top-bottom approach that we usually come in with as lawyers, that since these legal provisions have essentially been presented by the Constitution and law, then that should be essentially applied even by force, because over the years that has not worked. So we need to think of also a different approach, and also accept the reality that these customs are important for these particular communities. So it's a matter of finding a way to have a discussion with the gatekeepers about introducing equality provisions to their customary understanding. And I'm giving a chance to Justice Angote to respond to the same question, then I'll move on to another question.
Basically, what you've said is true, and what the questions and concerns that have been raised by the attendees is actually also true. We have very good laws, but the problem is when it comes to sensitization. I think both men and women are not alive to this changing status when it comes to equality. And as much as the judiciary is playing a role in terms of clarifying these issues, they can only do so once the disputes come to them. So it's upon the civil society and all the other people involved.
Okay, we are having a problem with Justice Angote once again. I'm going to read one comment from Rahab Mwati, who says that it seems we all have a common problem across the board in Africa. Implementation of the current laws is the problem. It is only after we successfully implement the existing laws that we will be able to remedy the legal gaps that are there. This calls for a lot of community sensitization and civic education. I'm putting a question essentially that is following up here to both Dr. Mandi and Rutendo, who are seated with us. Is it possible that society should make it mandatory, especially before entering into marriage, for parties to specifically enter into a contract on acquisition, possession, use, disposal, and inheritance or bequeathal of properties? Justice Angote, we have moved on. We'll come back to you later.
Okay.
This is a question from Albert Kamunde.
Okay. The Zimbabwean position is that our marriages are automatically out of community of property, which means that during the subsistence of a marriage, what is mine, what is his, and what is ours, meaning that what is jointly registered out of our will, the both of us, then becomes ours. So the issue of the marriage regime, it's also part in terms of the Zimbabwean context, it's part of a marriages bill. We are in the process of harmonizing our marriage laws to property rights and so forth. So with the issue and the recommendation from the Constitution, which says there should be equality of rights during marriage and at the dissolution of a marriage. So we are also having this conversation to change the marriage regimes into in community of property, like our fellow neighbors have done. Namibia has done it, South Africa has done it. And then in the instance where parties do not want to specifically own property or jointly register property with the consent of the other party, then it can be cleared up in an antenuptial agreement. So, but in terms of inheritance, that will be cured by the will. Someone can leave a will, and the will will specify who inherits what and at what point their property should be transferred to the party that will be surviving after the death of another.
Okay. Thank you, Fatima. There's a specific question thank you, Rutendo. There's a specific question for Dr. Mandu. It's from Godfrey Mercy, and he asks, could you talk more about why it has taken so long for Zambia to develop the land policy? Any prospects that the policy will be finalized in the near future?
Okay. On the land policy issue, the major problem has been, firstly, when you bring all the stakeholders on board, there is always conflict and arguments. And it seems like at one stage we were trying to say, okay, let's look at the side of the traditional leaders. Eventually, we changed a few things, and then it was the traditional leaders who started walking out. But it seems that the way in which the law reforms have been planned, it has just taken too long. And I don't know if our objective is to have a very perfect policy in the end, that we keep on debating and going back to the ground, collecting information, coming back again, debating, coming back again, debating. We just seem to be going in that sort of a circle. So I think we are not really sure what we want, because we are in the process, and I've just been told that the Customary Lands Bill has actually been drawn out, and then it was withdrawn. So we've got issues in our laws as well. And that is why we keep on going back and forth, back and forth, back and forth. The reason could be several. I think disagreements mainly is what is holding us back. But as I say, the policy document is a working document, and we have to move forward. So I'm hoping that this is the last time we have made comments on it. And hopefully this time the traditional leaders will not walk out of the meeting and will adopt it as a draft, as a final land policy for us to move forward with.
Okay, thank you very much, Fatima. I want to bring in another comment as well from Cynthia Orenge, who says that courts in Kenya have made progressive, Cynthia Orenge says, I think we should go to the grassroots, just talk to the women, and especially in rural areas, and see how they feel about these beliefs. Do they want them changed? And what should be done? This task should not start at boardrooms with the government task force, but center it on people who are adversely affected. Amio Chieng says that courts in Kenya have made progressive judgments in ensuring there is equality in division of property among the deceased children. However, this is usually not well received by the community, and the female children of the deceased are subjected to hostility once they demand for the share of their land. Our question is, how strong and effective are the law enforcement mechanisms to ensure safety of women in instances where the court gives judgment that is contrary to customary beliefs? Justice Angote, this probably still looks like the first question I asked, so that's why I'm bringing it back to you. And if your video gives you problems, maybe you can take it off. Yeah.
Thank you, Oliver. You know, when it comes to an enforcement of the court orders, I don't think the issue of the customs of a particular community should be an issue, because before a court delivers a judgment, it usually looks into the customs at play, and once the court pronounces itself on the customs at play vis-a-vis the law, then that decision has to be enforced. And until we enforce decisions, of course, it will be very difficult for even people to realize that indeed we are changing in terms of our thinking and in terms of the law. So in my view, customs cannot hinder somebody from enforcing a judgment of the court, and it's only through enforcement that indeed we will be enlightening whoever is concerned or whichever community is concerned of what the law provides for, and the decision of the court should be final. So it should not be an issue of what happens if the customer says otherwise. In my view, if we do that, then we'll be retrogressing. We will not be addressing the problem at hand.
Then,
and I'm sorry, I've been losing internet.
Okay, sorry. Then perhaps as a follow-up, what sort of enforcement are we talking about at this point? If you have that dichotomy between customary rules and norms and legal provisions, what would be the ideal form of enforcement for these circumstances?
The most effective enforcement in most cases is actually to reduce whatever the contest into a legal instrument and also a registrable instrument. Because if you are talking about ownership of land, then a judgment of the court should be enforced by way of having that particular interest of the woman to be registered, so that at the end of the day, the interest is in writing. And once the interest is in writing, then enforcement becomes easy, because the beneficiary of the judgment is able now to deal with that land outside the parameters of the community or the parameters of the customs. So the kind of enforcement is basically, in most cases, when we make decisions, and once we pronounce that the property or a piece of land is owned by a particular person, then that becomes a registrable pronouncement. And once it's registered, and then you can now be able to deal with that land without those shackles of the community or the customary law. So that's how I see it. You have to progress from the customary position to a registrable instrument, and then you can now deal with that land in whichever manner that the law allows you to deal with it.
Okay, perhaps, and this is a question I've picked from most of the comments here. There is also the reality of women living in these communities. And so on one hand, they receive these amazing judgments from courts, but sometimes they retract their demand of accessing the land because the conditions within those communities would not make it viable for them to operate that land. And so it becomes a balance of either them essentially acquiring their rights to their land and tending it, or ensuring that they don't completely get shut out of their communities or find it difficult to live there. And so when we are dealing with advanced law and these registered instruments for these rights, how do we balance that with the reality that women find themselves living with in these particular communities? So as one participant has asked, how do we deal with the gatekeepers, the traditional leaders, the ones who sit in dispute resolution mechanisms that are traditional, those communities that those women are going to find themselves living in? I'm asking this because I've seen a couple of cases. I think somebody had raised the case of Rachel Correll, the Kepchemboi case, the one where the 6 sisters, I think, managed to get a good judgment eventually, and they managed to get equal distribution of their father's property. But there was also a lot of pushback from the local council and leaders who felt that the constitution was interfering with their cultural rights. And how do we manage to move forward past that lockdown, where women find themselves at the center of their culture and their rights? Yes, Judge.
Yeah, just briefly before Rutendo takes off. All I wish to say is that women have to insist on their rights. I know even going to court in the first place is usually a problem because of those threats and the cultural beliefs. And even women themselves believe, or rather, they are afraid to go to court because of what you've just raised. And that also comes to the issue of enforcement. So it is women who should actually insist on their rights. And then, other than that, of course, the men are also supposed to realize that things have really changed. So until they insist on their rights and on the enforcement of their rights, it's going to take a very, very long time.
Okay, Rutendo?
Okay. From our experience, we've noticed that in certain areas, we've been able to break the barriers of cultural practices that continuously violate women, in that we have done constant trainings with community leaders and chiefs. And now we have seen that in certain areas, we even now have female leaders. And that balances culture and the rights of women, in that there is this area where women were also not allowed to inherit property, but because of the involvement of women, they managed to get the disservice, or the, what can I say? They managed to get the of the dispossession of women and land, when it then came into conversation of the people that they know, the people that they are familiar with. Because most of these cultural practices, they continue to be endorsed because there is no clearer explanation or a clear picture of the ripple effects of such dispossession and such forced dispossession of property from women. So the continuous engagement of traditional leaders in this, and in most instances, these traditional leaders, some of them also sit in parliament. They get to also influence their peers, their peer or subordinates, their traditional leaders, on the exposure that they also get, because most of these leaders are not getting enough exposure. But having an involvement of traditional leaders in parliament, who are then trained on the law, who are then sensitized on the implications of not being gender sensitive when presiding over these property dispute hearings, and separation of people in African customary law unions and so forth, it then gives them a realization of the impact of such dispossession to women. So when they are then dealing with these matters, they are more gender sensitive because they are looking at the impact of it. And in most cases anyway, African women, once they settle in another place, once they get married and settle with their husbands, they tend to be erased from their own family backgrounds as having moved on to the next. So disposing them will then have those ripple effects. So having to sensitize these African leaders, it gives them a better understanding, and it gives them a standpoint of wanting to continuously to even advocate for their relatives, or also women, their wives, and so forth.
Okay, thank you very much, Rutendo. That was a whole-rounded answer. Perhaps Fatima, do you want to respond to that before I ask the final round of questions?
Yeah, I would just like to add to say it's a change of mindset. And if we are going to achieve a change of mindset, be it any culture, I think it's over a period of time, and convincing the women themselves to say, look, you are not just being a feminist, you are trying to achieve something in reality, which is going to help generations to come.
Okay, thank you. A change of mindset. It's essentially a balance. If you're dealing with cultural attitudes and cultural rules, I actually come from a perspective that normative norms that essentially come out of culture, they are very capable of changing because they're based on context, but that requires a cultural and contextual change and shift of mindset. I actually think customary law and cultural law is capable of changing more than statutory systems, and because those ones you need to follow processes, and you need to which is essentially long and requires consensus. But I think customary rules and norms are essentially about who is influencing them and for what reason. And so I think we cannot have this discussion without bringing into the fold the gatekeepers of customary norms and customary rules. It becomes very important if we are talking about change as a way of influencing the process and making it easier for women when they have very good decisions in their favor to be able to come with these decisions into their community and be able to live in those communities with those decisions they have to access their land. An interesting question that came through is a question from Carol, who asked a specific question regarding families' land that was divided under customary law, sometimes in the 90s. and that ended up bequeathing the land only to the sons in Kenya. And statutory law later changed to allow even married daughters to inherit land. So our question is, do married daughters automatically deserve a portion of land that was previously already divided amongst only sons under customary law? Yeah, anyway, that's straightforward, but Justice Angote, can you take this one?
Yes. We since 1981, the law has allowed married daughters to inherit their father's land, or their mother's land, for that matter. So what the person who's asking the question means is that the issue of succession was done under that patrilineal stage, and she was never involved. We have, under customary law in Kenya, we have a concept called customary trust. This is where maybe the elder brother or even sister holds land in trust for the rest of the family members. So more often than not, you find that the brothers end up actually subdividing the land amongst themselves and even getting titles. That means they actually did the succession of that particular piece of land, probably without the knowledge of their sisters, or maybe their sisters just acquiesced to that particular position. Now, the law of succession, there's no limitation of time. You can still raise the issue and say, I was entitled to this particular piece of land, but I never managed to get any portion of it. So there's no time limit. They can still raise that particular issue and say that the Law of Succession Act was never followed because they were excluded. But as you've said, Olivia, most of these issues usually happen because of fear, and then secondly, because you don't want to antagonize the family. For the sake of peace, that is the word that is usually used more often than not by our sisters and mothers. That because we want peace, we are not going to fight with our brothers. We are not going to ask for any portion of land. So that is what might have happened with the issue at hand. But if that's not what happened, and they never considered even in court, then they still have a right to actually raise that issue and say that they are entitled to that particular piece of land because they are daughters of their deceased father.
Okay, thank you very much, Justice Angote. I want to bring in two interesting comments from our participants. Mili Luanga says that in Kenya, quite a number of communities actually have land preserved for wives, perhaps not for daughters, even those with children. But it is this system of private titles that has suddenly seen the mushrooming of culture that is so unequal. And I think this goes back to the discussion that culture evolves because it's contextual and it keeps changing. And so it can take into context, including contexts of self-interests, monetary contexts of pushing for private rights to land as opposed to communal, depending on what the context is. And so in this case, perhaps argument is that the privatization of rights to land is what has led to such unequal forms of culture. So I just wanted to read out our comment. And the second comment I wanted to read is from Chris Owala, who says that we have been documenting a lot of widows and orphans when it comes to land disinheritance cases in the Siaya County. And this is in Western Kenya. In most cases, you find the court, provincial administration, and land officials are at the center of the injustices as well. And this is the reference I was having to implementers. So it's not just about the law, it's not just about the customary rules and norms, it's also about the parties that are implementing the law and legal rules. It's about engaging with them as well. So it says, what can we do together for the purposes of getting justice for the underprivileged in society? I feel that is a general question that we've been answering throughout the discussion. And Agnes Omenta Maria says that in Zimbabwe, the land issue is really deep. The culture on gender parity is intense, quite sensitive, but Rutendo, you have done a good job in explaining and bringing out the problems and challenges as they are. Thank you for that background. That has been helpful. And so one last question before we close. I'm taking this question from oh, the person did not put a name. They are a bit anonymous. Thank you for this discussion. My question goes to Justice Angote, but I'm also extending it to all of you. When it comes to matrimonial division of property, it is almost inevitable to talk about the issue of contribution. What are the courts doing to make the assessment of non-monetary contribution more realistic? This is in reference to a lot of women who are considered to be giving non-monetary contribution.
Yes, Olivia, you want me to answer that?
Yes, and I'll also extend it to the other parties as well.
The question of division of matrimonial properties act, I think that one is governed by a different statute altogether. Though it was not part of our discussion, but all I can say is that the courts in Kenya have really insisted and have really enforced the Matrimonial Properties Act, which specifically states how matrimonial property should be divided between spouses. And the courts have been very categorical that the issue of non-monetary contribution of most of our sisters and mothers is very, very critical, and they have been assessing it, and in most cases they have even been assessing it to be even more than 50%. So the issue of assessment of non-monetary contribution of a spouse, and in this instance, it's not just the woman, it's both sexes, is an issue which differs from one dispute to another. So I cannot give a fast and hard answer on that issue, but each and every case has got its own peculiar circumstances, and the courts will always assess the monetary contribution of a spouse depending on the circumstances of the case. The Matrimonial Properties Act actually provides for that, and the courts have been doing that.
Okay, thank you, Justice Angote. Do any of you, Fatima and Rutendo, have something to say as we wind up?
Yes, I can just speak to the Zimbabwean position. We have what we call the Matrimonial Causes Act, which looks at the issues of contribution, direct or indirect contribution at the dissolution of a marriage. And as Zwala, we actually have a fresh judgment that has actually awarded 50% share to a woman on property that they acquired during the subsistence of their marriage, but which she did not have a direct contribution on. So I think maybe you can refer to it. It's called Mora versus Mora. The judgment just came out last week, but one. So it's quite very fresh, but our Matrimonial Causes Act is quite clear on what would be considered. There is direct, there is indirect contribution. Not only the monetary contribution will be looked at, but other things, and it permits women to then benefit on sharing of property, even on sharing of property which is in land value.
Okay. Thank you. And perhaps as Justice Angote had said, this discussion comes in more when we're talking about registered properties, especially within an urban setting, as opposed to the discussion we are having on property within communal setting, but it's nevertheless still important. Dr. Fatima Mandu, do you have anything to say when it comes to not just this discussion, but the whole larger discussion that we've been having? How do you think we should move forward past this issue of maybe discrimination in customary norms and the displacement of women within, for instance, the context of Zambia? How can the government, the law, and people who are traditional leaders at the center of this come into play in addressing this women's exclusion?
Okay, just to wind up and say that talking about direct and indirect contribution on matrimonial property, I think we have similar rules in Zambia as well. It's called indirect contribution, which women make towards acquisition of a property, but it really doesn't go to the roots of real property. I think it's more so on other type of property in Zambia. I haven't come across anything, but I don't teach law of succession, so I may not be accurate on that. In terms of winding up, for me, I still feel that there is a lot of gender gaps in our laws and also gender gaps in the way our judgments are being given. And the best way to tackle would be to say, firstly, we need to understand the whole concept of gender and then look at women's rights in particular by training, change of mindset, of course, raising awareness as well, and then getting women to push for their rights, to be the forefronts of trying to push for their rights. I think women are there, but they are not really visible. Somehow they are not visible. And one of the papers that I came across, which really interested me, was how we can even go to the extent of saying that women's labor in the home should actually be paid labor. Of course, it's a very big debate on other issues, but I'd like to end.
Okay, thank you. And in closing, I want to read one statement by Lilian Zumuna that encapsulates what Fatima said, but also the whole discussion we are having. It's a multifaceted discussion. It's not just about law. It's not just about culture and customary norms. It's not just about gender. It's not just about exclusion. It goes deeper than that. So she says that the change is very difficult, be it positive or negative. Any change is difficult. It often invokes fear in individuals, and it's surrounded by some sort of uncertainty. Hence, we need to pay attention to this fear and address it to the best of our abilities. Men are scared that the whole system of land ownership, if changed, might be disadvantageous for them. Accordingly, there is need for them to be informed of the true position and benefits of change that would be brought, not just for the women, but for the community. It's not a struggle between gender. It's simply an integration of women's rights into the larger framework. And with that, I want to take this opportunity to thank all my panelists, Dr. Fatima Mandu, Honorable Justice Oscar Angote, Ms. Rutendo Shamaine, and Dr. Makanatsa Makonese, who was sharing with me. She's still here somehow, and Mr. Peter Wendo, as well as Africa Tech Hub, and everybody else who has supported us in getting this going. I also want to take this opportunity as well to thank our participants who have been amazing. They have maintained the discussion. They've been here, most of them all the way to the end. They've asked very incisive questions and made very interesting comments that have made this discussion much more richer. And thank you and goodbye. You have a good day. Bye-bye, everyone.